Hello students, welcome to the lecture on intellectual property rights, and after this lecture we will be able to learn the following objectives. Explain concept of intellectual property rights. Describe the types of intellectual property rights. Discuss the Right to Information Act 2005. Explain the Environment Protection Act 1986. Describe the laws related to competition and packaging. Explain the law of fair trade practices and banking regulation. Explain the law of shops and establishments. Let's start with the concept of intellectual property rights. Licensing intellectual property is important to all sorts of businesses, not just those in the technology sectors. Companies can derive significant income from licensing, and licensing can offer flexibility in the way a business develops. The main intellectual property rights, IPR, include copyright, patents, trademarks, and designs. Know-how, trade secrets may also be an important element of an intellectual property portfolio and can be protected by confidentiality, non-disclosure agreements, and the law of breach of confidence. The management and licensing of the different forms of intellectual property can be important to the success of the business that invents or creates a product, to manufacturers, to the designers that configure or refine a product's appearance, and to the producers of packaging and marketing literature and materials. A licensee is a permission to do something that without the licensee would be an infringement of IP. The person granting the license is usually called the licensor, and the person receiving the licensee is usually called the licensee. There may be more than one licensor or one licensee in a license agreement.
Intellectual property rights are about more than just music and movies. They're in everything we do, make, use, eat, buy, and sell. Trademarks, geographical indications, patents, designs, and copyrights all support and promote our industry's economy, jobs, and innovation. IPR play an essential role in half of European businesses. And IPR support 1 in 3 jobs in the European Union. That's over 76 million jobs. IPR-intensive industries pay 40% more than other industries. Altogether, IPR-intensive industries contribute nearly 40% of the EU total GDP. That's 4.7 trillion euros. And that means more money for improving our communities. IPR-intensive industries account for 90% of the EU's trade with the rest of the world. IPR affect our daily lives in more ways than we can imagine. From creativity and innovation, to businesses small and large, to the economy in all member states. We all care about protecting intellectual property, and we can all contribute. Our everyday choices make a real difference.
Let's now discuss the concept of intellectual property rights. The IPR are legal rights which result from intellectual activity in industrial, scientific, literary, and artistic fields. These rights safeguard creators and other producers of intellectual goods and services by granting them certain time-limited rights to control their use. Protected IP rights, like other property, can be a matter of trade which can be owned, sold, or bought. Features of IPR. The IPR are property rights over information, knowledge, and ideas. The IPR are exclusive, tradable, and temporary. The IPR differ in the information being protected: copyright, patent, trade secrets, trademarks. The IPR protect information that has public good characteristics, non-excludability, and non-rivalry consumption. Nature of intellectual property rights. The relevance of intellectual property protection to day-to-day activities has been repeatedly shown to be a settled matter. Humanity seems bent on creating a world economy primarily based on goods and services that take no material form or shape. And just as nature of property changes, so is the system of its exploitation. This chapter looks at the evolution, nature and scope of the traditional fields of intellectual property law that seek to protect the rights of inventors and authors to control or exclude others from unauthorized exploitation of their mental creations. Importance of intellectual property rights. Intellectual property (IP) contributes enormously to national and state economies. Dozens of industries across our economy rely on the adequate enforcement of their patents, trademarks and copyrights, while consumers use IP to ensure they are purchasing safe, guaranteed products. We believe IP rights are worth protecting both domestically and abroad. Intellectual property creates and supports high-paying jobs. IP-intensive industries employ over 55 million Americans and hundreds of millions of people worldwide. Jobs in IP-intensive industries are expected to grow faster over the next decade than the national average. Intellectual property transfer arrangements. An intellectual property transfer agreement is used to protect intellectual property. It contains an agreement decided on between two or more parties and all information relating to the arrangement made. It is used when allowing another person use or ownership rights of another person's intellectual property. These agreements are also called intellectual property agreements. Intellectual property (IP) is not actually tangible property. It is property created by the mind, including things such as literary and artistic works, symbols, images, and inventions. Two categories of IPs exist: industrial property and copyright property.
Hi, my name is Jennifer Marles. I'm an associate with Oyen, Wiggs, Green & Mutala. We're a law firm that practices just in the area of intellectual property law, and today I'm going to give you my top 5 tips for new people just starting out. My first tip would be that timeliness is very important for intellectual property rights. For example, most countries require that you have filed an application for a patent before you have any kind of public disclosure of your idea. If you don't do so, you could lose your right to obtain patent protection in many countries. So, it's important to get help at an early stage to identify what deadlines you need to meet and make sure you take steps to meet them. My second tip relates to trademarks. When you're selecting a trademark, it's very important that you conduct searches to make sure that no one else is out there in the marketplace using a similar trademark and that no one has registered a similar trademark. If you do a search ahead of time, you can help avoid potential disputes down the road. My third tip is once you've chosen a trademark, go ahead and take steps to register that trademark. In Canada, having a trademark registration gives you nationwide rights. Also, by registering your trademark, you put your rights into a database that other people can search when they want to choose their trademark. This makes it more likely that someone will not choose the same trademark that you already adopted. My fourth tip would be that it's very important to use clear contracts to carefully define your relationships with other people. By having a contract that sets out the expectations of both sides beforehand, you can make sure that everyone is clear on what their obligations are, and you can avoid disputes down the road. My fifth tip would be that it's very important to get good advice at an early stage as to the options available to you to protect your idea. Many people come to us looking for one specific type of intellectual property protection, such as a patent. But the reality is there may be multiple different ways that they can protect their ideas and advance their businesses. So, at an early stage, it's a good idea to get advice from people to help you determine what options are available to protect your idea so that you can choose the one that best suits your particular idea and your budget.
Now moving on to the next topic, we will study the types of intellectual property rights. Intellectual property, IP, has been traditionally categorized into industrial property and copyright. The term industrial property includes patents, trademarks, industrial designs, and geographic indications of source. Copyright protection is granted to protect literary, artistic, and musical works. Rights related to copyright include those of performing artists in their performances, producers of phonograms in their recordings, and those of broadcasters in their radio and television programs. IPR are generally said to be a bundle of exclusive rights granted to the lawful owner. Global commerce brings with it the need to protect intellectual property assets around the world, a process that can be confusing and difficult. Although in some areas like Europe and Africa, regional protection is available, in most cases, patent and trademark protection must be achieved on a country-by-country basis. Developments of new products and processes, brand names, content, and so on are resource intensive and usually require huge investments. It is therefore the expectation of the individuals or entities creating them that they have exclusive rights over their creation to the exclusion of others. Intellectual property system and laws essentially provide their exclusivity. The agreement provides for norms and standards in respect of following areas of intellectual property: copyrights, patents, copyrights and related rights. The copyright law has been amended periodically to keep pace with changing requirements. The recent amendment to the copyright law, which came into force in May 1995, has ushered in comprehensive changes and brought the copyright law in line with the developments in satellite broadcasting, computer software, and digital technology. The amended law has made provisions for the first time to protect performance rights as envisaged in the Rome Convention. Patents. The basic obligation in the area of patents is that invention in all branches of technology, whether products or processes, shall be patentable if they meet the three tests of being new, involving an inventive step, and being capable of industrial application. International protection. Intellectual property is recognized internationally through a system of treaties and international organizations. The most important organization is the World Intellectual Property Organization, WIPO, a special agency of the United Nations.
Of ABI's Quick Fit video series. I'm Lisa Fox with ABI, and I'm here with Jessica Susie at Brick Gentry. And we had a couple of conversations some time ago about patents and trademarks. And I'd like to drill just a little bit deeper into the different types of intellectual property. Can you expand on that a little bit?
Sure. The four main types of intellectual property are patents, trademarks, copyrights, and trade secrets. Some related types of law are licensing and unfair competition. But as far as the four main types, patents, trademarks, copyrights, and trade secrets, and for example, a trademark is a word, symbol, name, device that's used to indicate the source of goods from one party and distinguish the goods and services of other parties. A copyright is a form of protection for works of authorship, works of expression, such as books, articles, architectural works, drawings, paintings, and the like. A patent is a legal grant from the federal government that gives the owner the right to exclude others from practicing a specific invention. And the types of inventions are machines, articles of manufacture, compositions of matter, and methods or processes. And finally, a trade secret is information that has economic value from the fact that it's not readily known or easily ascertainable, and reasonable efforts are made to maintain the secrecy of the information.
So would a trade secret be something like a recipe?
It could be a recipe. For example, a very famous one is the recipe for Coca-Cola, but it can also include client lists, supplier lists, specific methods or processes for manufacturing an item, chemical compositions.
Gotcha. Well, I would assume that there are similarities in how all of these different intellectual properties are obtained, but I would assume there are differences as well. Can you talk about that?
Correct, absolutely. Well, with the copyright and the trademark, some rights are given to the owner just by using the trademark or creating the work that would be subject to copyright protection. However, both of those items can also be federally registered, so you can register the item with the Copyright Office or apply to register the trademark with the United States Patent and Trademark Office. Trademarks can also be registered with a particular state. As far as the trademark office goes, the application is submitted and then an examining attorney will review the application, and sometimes there can be some back and forth about that. With respect to a patent application is submitted into the United States Patent and Trademark Office, and then in time it's examined by an examiner at the office, and usually there's some back and forth as far as maybe narrowing the scope of the patent or whatever the case may be.
Gotcha.
As far as the trade secret, essentially it's just by keeping the information secret, having that supplier list, that process, whatever the case may be, and keeping it secret and letting others know if you do have to tell them the information that it's secret.
Gotcha. And I would assume there's a difference in the terms for this intellectual property too. So how long? Talk about that.
Well, with a trademark, it can really be indefinite. You start having some rights as soon as you use the mark, and then it lasts as long as you are using the mark. With respect to a patent, generally the term is 20 years from the date of filing, not necessarily the date the patent issues, but the date of filing. With the copyright, it is, for an individual, usually the lifetime of the author plus 70 years. And work made for hire, such as an employee situation, would be 95 years from the first publication, or 120 years from the date of creation, so much longer than the patent. And then with the trade secret, really as long as the information is secret.
Interesting. And you talked about a little bit earlier about like Walt Disney.
Right. They've been very instrumental in expanding the term.
Let's know the Right to Information Act 2005. An act to provide for setting out the practical regime of right to information for citizens to secure access to information under the control of public authorities in order to promote transparency and accountability in the working of every public authority, the constitution of a Central Information Commission and State Information Commissions, and for matters connected therewith or incidental thereto. The Act requires the government to compile a guide in easily comprehensible form and to update it from time to time. The government has already published 4 guides in the past, one each for the information seekers, the public authorities, the central public information officers, and the appellate authorities. Here is an updated consolidated guide for the use of all stakeholders. The Act begins with the obligation on the government agencies to publish in the Federal Register information about the organization of the agency, functions, procedure, the persons, officials from whom information can be collected, the availability of forms, the scope of information available, the substantive rules and statements of general policy or interpretations of general applicability adopted by the agency, adamants thereof. Time period for compliance with a request is 10 days from receipt of the request. Decision will be notified immediately to the requester with reasons. In case of refusal, it must mention the right to the requester to appeal to the head of the agency and the names and titles, positions of the person responsible for the denial. The time limit is extendable with notice and reason, but only for a maximum of 10 more days. Such extension is allowed for search and consultation time. In this Act, unless the context otherwise requires, environment includes water, air and land, and the interrelationship which exists among and between water, air and land and human beings, other living creatures, plants, microorganism and property. Environmental pollutant means any solid, liquid or gaseous substance present in such concentrations as may be or tend to be injurious to environment. Environmental pollution means the presence in the environment of any environmental pollutant. Handling in relation to any substance means the manufacture, processing, treatment, package, storage, transportation, use, collection, destruction, conversion, offering for sale, transfer or like of such substance. Laws related to competition. Competition law is designed to protect businesses and consumers from anti-competitive behavior. The law stipulates effective competition in order to deliver open, dynamic markets and enhanced productivity, innovation and value for customers. All businesses must comply with competition law, and there can be serious consequences for businesses and individuals, including directors, for non-compliance. In this law, the following terms shall be construed as follows. Relevant market consists of relevant product market and relevant geographical market. Relevant geographical market means a specific geographical area in which goods or services may be substituted for each other with similar competitive conditions, and which area is significantly different from neighboring areas. Industry association consists of trade associations and professional associations. Practices in restraint of competition means practices of enterprises which reduce, distort or hinder competition in the market, including practices being agreements in restraint of competition, abuse of dominant market position, abuse of monopoly position and economic concentration.
Richard Wish is one of the country's leading authorities on competition law.
Well, the most serious anti-competitive agreement is what we call a cartel. And that's the situation where a number of competing businesses get together and basically decide, let's not compete with one another. The most obvious example of a cartel is a price-fixing agreement, and that's where a number of competitors get together and they agree to fix their prices. For example, they might all agree that next Monday they will put their prices up to an agreed level. What we can say quite simply is consumers get a raw deal from cartels. We come across very obvious cartels where firms simply agree to fix prices, but you can imagine more complicated examples. One would be what we call bid rigging, and this is where a firm goes out to competitive tender, asking a number of companies to bid competitively to win a contract. And what they do is they get together and they decide it is my turn to win the next contract. So it is agreed that I will bid a price of £1 million, somebody else will bid 1.2 million, somebody else 1.4 million. Well, obviously I will win the bid, and we have created the illusion of competition, and clearly the likelihood is that the price even of £1 million is higher than the competitive price should be. Very interesting thing about cartel activity is that it can take place at a number of different levels within a company. I mean, you could imagine a situation where somebody from the board of directors of company A has discussions with a director of company B, or this might all take place at a much lower level where perhaps salespeople from two different organizations have discussions with one another. And there are also examples where the exchange of information sometimes takes place through a third party, for example, a trade association. It's a very important thing for business people to understand that cartels don't only mean cloak and dagger operations. If competitors are all together at a social event, for example, they go to a trade association dinner, and then after the dinner they go to the bar, and they start talking to each other about their future plans and that they're thinking of raising prices, this can also be illegal.
Laws related to packaging. The link between food packaging and consumer protection is of high significance. A package is a vehicle of safety and achieves the objective of delivering safe, wholesome, nutritious food to the consumer. To safeguard the interests of the consumer and the society at large, packaging laws and regulations have been introduced by the government. The packaging laws and regulations for food products are mainly covered under the Standards and Weights and Measures Act 1976 and the Standards of Weights and Measures Packaged Commodities Rules 1977 SWMA. The Prevention of Food Adulteration Act 1954 and the Prevention of Food Adulteration Rules 1955 and its First Amendment 2003 PFA. The Standards of Weights and Measures Act SWMA. Till about 25 years ago or so, the consumer was not sure that he was getting for his money the right weight or volume of the packaged products. Things were pretty chaotic with different states having their own system of weights and measures. The Prevention of Food Adulteration Act. Food is one of the basic necessities for sustenance of life. Pure, fresh and healthy diet is most essential for the health of the people. It is not wrong to say that community health is national wealth. Adulteration of food was so rampant, widespread and persistent that nothing short of a somewhat drastic remedy in the form of a comprehensive legislation became the need of the hour. Law of Fair Trade Practices. The Fair Trading Act protects consumers from unfair business practices before, during or after a consumer transaction. The legislation applies if the consumer or supplier lives in USA, the offer or acceptance is made in or sent from USA. A consumer transaction is defined as any sale, lease or the transfer of goods or services for payment. This includes a contest price and goods or services given to someone else. The consumer is an individual who pays for those goods or services. Goods generally refer to material items used primarily for personal, family or household purposes. A new residential dwelling, whether or not it is attached to land. Law of Banking Regulation. Banking law covers the many state and federal regulations governing financial institutions. Attorneys who practice in this area of the law handle everything from customer disputes and complaints against a bank to complex litigation between domestic and foreign institutions, their investors, the government and other parties. However, most banking law attorneys are hired to provide advice concerning regulatory compliance. Banks may choose to maintain in-house counsel for this purpose or to seek assistance from an independent law firm. Given the vast number of regulations with which banks must comply, it is not surprising that their officers and directors seek legal counsel before making important decisions. The Dodd-Frank Act, a banking reform measure passed by the federal government in 2010, alone contains more than 1,500 separate provisions, including nearly 400 rule mandates. Regulatory compliance. In the current regulatory environment, banks have no choice but to make compliance a priority. This can involve an expensive and labor-intensive process that will affect everyone within the organization. First, the applicable rules and regulations must be identified and ranked in order of the risk associated with non-compliance. This evaluation by itself will often require input from an attorney familiar with the bank's operations. An effective compliance plan must be comprehensive, and here too the bank will benefit from the advice of counsel. The new efforts must be integrated with existing compliance systems to produce a complete, streamlined approach. Defending enforcement actions. Of course, if a bank is already the subject of regulatory investigation or enforcement action, the objective changes. Now the goal is to defend against inaccurate allegations and to protect individuals within the organization who have been singled out. There are many examples of overzealous regulators abusing their authority to the detriment of innocent directors, officers, and employees. Imprudent enforcement actions can also harm a bank's reputation and disrupt day-to-day operations. Law of Shops and Establishments. The Shops and Establishment Act is a state legislation act, and each state has framed its own rules for the act. This act lays down the following rules: working hours per day and week, guidelines for spread over, rest, interval, opening and closing hours, closed days, national and religious holidays, overtime work. Development of shops and commercial establishments. The Shops and Establishments Act of different states extend to the whole of the state, and within each state it covers such areas as the state government may notify from time to time. The condition of employment of persons employed in shops and commercial establishment are generally regulated by state acts and rules framed thereunder. Now in the end, let us summarize what we have learnt in this lecture. the criminalization of the bribery of public officials, both domestic and foreign, and the enforcement of these anti-bribery laws are a key component of a comprehensive anti-corruption framework and complements parallel efforts to prevent and detect corrupt behavior. The Foreign Corrupt Practices Act is a federal law enacted in 1977 to prohibit companies from paying bribes to foreign government officials and political figures for the purpose of obtaining business. The Foreign Corrupt Practices Act (FCPA) generally applies to all U.S. corporations, partnerships and other business organizations, generally a company, as well as all persons acting on behalf of those entities. Nationalization is when the government takes over a private company and run them themselves. Most possibly when companies have found themselves in a bad financial way and the government pretty much bails them out. Judgments from non-reciprocating territories can only be enforced by filing a lawsuit in court for a judgment based on the foreign judgment.